Welcome to the Remedies video lecture series. This is lecture 4, and this lecture will discuss personal injury damages. This lecture involves personal injury damages and will cover a number of topics, including the single opportunity rule, the burden of proof, quantifiable and non-quantifiable losses or economic and non-economic damages, lost earnings and lost earning capacity, special issues with non-economic damages, and finally, related losses to others, that is, what is known as the loss of consortium. Let's start with the single opportunity rule. Basically stated, there is one trial and one opportunity for the plaintiff to prove and obtain damages for past, current, and future injuries and losses. This works well for past injuries and losses, obviously, because those can be documented with a great deal of accuracy. The problem becomes when we're discussing future injuries that may occur as a result of the defendant's conduct and future losses. Number of issues. How do we determine the present value to award the plaintiff at the end of trial for injuries and losses, care, and everything else that will occur years from now? This assumes also that the plaintiff will wisely manage their money so that they will have it at the time when it is needed in the could-be distant future. And what burden of proof should we impose for future events? What should we require the plaintiff to prove in predicting what will occur in the future? So, present value equals the payment today for needs in the future. This will include everything from lost wages, lost earning capacity, future care and services, including medical care, medical operations, hospitalizations, care that may be needed as a result of the injuries into the future, etc. This raises the old problem that we've been discussing throughout when we talk about damages of not punishing the defendant and not providing a windfall to the plaintiff. The object of all damages is to make the plaintiff whole, but again, not to punish and not to provide a windfall. And the problem that we have with when we have a single opportunity rule is that how do we predict into the future and how do we calculate what money is needed? Let's see how this works. Present value. Obviously, it's based on a one-time payment. Again, the single opportunity rule, there's a payment that occurs, the jury determines what the damages are, and they order that the defendant make payment shortly after the trial to the plaintiff. Okay, number of things we should talk about in figuring out how to determine present value. There's something known as the real interest rate. This is the price of money without inflation. This is what in the marketplace one would charge to loan money for 1 year without any inflation and with very little risk. That is, if a party knew that they were giving someone else their money for a year, what they would charge at the end of that year if they were fairly assured of getting it back and they were fairly assured it would be at the same value at the end of the year. Inflation. Inflation is simply reduced buying power. If a loaf of bread today cost $1, if in a year from now it costs $1.25, well, that $1 has now been reduced and the loaf of bread is now 25 cents more at the end of the year. So the $1 is now buys less than it did a year ago. So that's inflation just reduces the buying power over a period of time so that money is worth less over time. The dollar today may be worth 75 cents in a year. If inflation is running at 25%, it could be worth 50 cents in 2 years. So you can see how this can affect what is awarded a plaintiff. The market interest rate is made up of several factors. It is the real interest rate, that is, the interest rate that one would charge to loan money without inflation and with minimal risk. But the market interest rate also includes money that is paid, part of the interest rate, money that is paid based on what risk is perceived to be involved. The more risk, the higher should be the interest rate. Plus, it should have built into it an inflation factor. Otherwise, loaning money would return less money at the end of the year if this inflation factor were not built in. And finally, we get to the discount rate. This is the rate that we would reduce whatever is awarded, the total amount awarded, based on the best and safest investments. Those are investments with minimal risk, usually referred to as corporate bonds on very well-established corporations. Obviously, the best and safest investments are U.S. Treasury bonds. And this is the rate that future amounts of money would be discounted or reduced to present value based on this discount rate. Let's see how it works in practice. So let's assume that the plaintiff should be awarded for their injuries $50,000 a year for 10 years. This could be lost wages, lost earning capacity, a number of things. They need $50,000 of medical care each year for the next 10 years. Well, it would be simple. How do we get, the goal here would be to get to zero at the end of 10 years. So each year they would take out $50,000 and get to zero at the end of 10 years. Without the single opportunity rule, we would just order the defendant to pay the plaintiff $50,000 in year 1, $50,000 in year 2, etc., etc. Or to buy an annuity, whatever the company selling annuities would charge, that would pay $50,000 each year. And this is sometimes what is done in order to protect the plaintiff and the defendant. But if this is not done, how do we get to zero at the end of year 10? And as we've said earlier, we can only make one payment at the beginning of year 1. So one payment at the beginning of year 1 with the goal of getting to zero at the end of year 10. Well, we could award $500,000, $50,000 a year, 10 years. It just straight out award $500,000. But what's the problem with that? If the plaintiff takes that $500,000 and invests it at 3% and takes $50,000 per year, they will end up with $81,568 at the beginning of year 10. And remember, they only should get $50,000 a year at the beginning of year 10. As a result, they will have obtained a $31,568 windfall. That is an advantage. Or, looked at the other way, the defendant will have paid a penalty of $31,568. Either way, this should not occur, and that is why we try to reduce the award to present value. In this instance, if the plaintiff were paid $476,510 and was able to earn 3% at the beginning of year 10, they would have exactly $50,000. No penalty, no windfall. That's what is known as reducing the money to present value. Straight out, you know, if there was just, we could get 3% interest, but, and this is a very, very large but, we're trying to predict into the future. We're trying to predict interest rates into the future, and more importantly, we're trying to predict inflation, because if we only award $476,510 based on the 3% discount rate, and predicted into this is 5% inflation a year, then at the beginning of year 9, the plaintiff will only have $31,000. And remember, they needed $50,000 worth of care or whatever at the beginning of year 9 and the beginning of year 10. And under this scenario of a discount rate based on 3% and inflation running at 5% a year, they will only have $31,000 at the beginning of year 10 and nothing at the beginning of year 9, excuse me, my mistake. They will only have $31,000 at the beginning of year 9 and nothing at the beginning of year 10. This then penalizes the plaintiff and actually rewards the defendant. In reality, they would need $622,500 to get to $50,000 at the beginning of year 10 if inflation is running at 5% and they can only invest their initial investment, the initial award, at 3%. So you can see how this can be rather tricky to figure out where to discount or where to reduce the money to present value, because we are trying to make several predictions into this. We're trying to predict interest rates, and more importantly, we're trying to predict inflation, which is extremely unpredictable. As I've said, impossible, almost impossible to predict inflation. It can go up, it can go down. We've been living in a time in the recent past of very low inflation, but I can remember a time back in the 1980s where inflation was running at 10, 15, 20% a year, and interest rates as a result were extremely high. They were 15, 16% a year, when today they're at 1 or 2%. As a result, courts have used a variety of methods to predict present value. They will sometimes use what is the real interest rate and leave it to the market. They will sometimes try and factor in a predicted inflation. The problem with that is that it can be too high, it can be too low. Most often, as a result, courts will use, as we saw in the cases in the book, the real interest rate. That is the base price for loaning money without risk and without inflation, and then assume that the plaintiff will take that money and invest it at market rates, which will include risk and will include inflation. The problem here is that markets usually lag behind either way. They will underpay at a time when inflation is increasing, and they're likely to overpay at a time when inflation is decreasing. So this can be a problem for both parties, and this is a problem that vexes the courts in personal injury cases. Let's talk about burden of proof for a minute. The burden of proof is that the plaintiff must prove damages to a reasonable certainty. Now, this is not as difficult for past damages when the plaintiff has been out of work for 10 weeks in the past. That's reasonably easy to do. When the plaintiff has past medical bills, again, not very difficult to do. The problem becomes future damages. When you have to prove damages to a reasonable certainty, that means that you have to prove what expenses will be incurred, what damages will result next year, the year after, 10 years from now, 20 years from now, and potentially 30 or 40 years from now, depending on the nature of the injury. Obviously, there are special problems of predicting the future, especially when certain events are less than 50% likely to occur. But if they do occur, they can have traumatic impact on the plaintiff. And remember, as a result of the single opportunity rule, the plaintiff cannot come back 10 years from now and say, we mispredicted how much my operations were going to cost. Remember, at the time, we only predicted that there was a 30% likelihood that I would have to have a $100,000 operation. Well, guess what? That 30% occurred, and I was not awarded damages for it. In that instance, the plaintiff is out of luck. Based on the single opportunity rule, they have to ask and prove those damages at their trial. And this is very difficult for future medical, for future care, and for various other uncertainties into the future. Let's talk about how damages are divided up in personal injury cases. They're often divided up between economic and non-economic losses. When courts refer to economic losses, courts or statutes, they're generally referring to losses that are quantifiable in terms of money. And this will become obvious. Medical and care expenses, so doctor's bills, hospital bills, nursing care, psychologists, physical therapists, care in home or in facilities. They also include lost opportunities, that is, lost wages, lost earning capacity, lost education, and various other costs and expenses, but they are those that can be documented and reduced to money rather easily. Non-economic damages are not easily quantifiable. You can't put a ready price tag on pain and suffering, on mental and emotional distress, on the loss of the enjoyment of life, and various other losses, or losses to others. So others' loss of companionship, loss of consortium, as we'll see in a few minutes. These are not easily quantifiable. We can't put a dollar figure on the loss of a use of a hand, on the loss of the use of a limb, on a leg amputation, on a paraplegic. Those are very difficult to put quantifiable amounts on, and as a result, they are referred to as non-economic damages. There are also damages are broken down in another way. We have general and special damages, and we've seen this before in contracts. General damages are those that naturally flow from the injury. They don't have to be pled with specificity. And in this instance, they include pain and suffering, lost earning capacity are two examples. Special damages are particular to the plaintiff and must be pled and prove the causal relationship between the injury and the loss. These involve medical bills, lost earnings, future medical and care costs. These are considered special damages and must be pled. Let's talk about one type of economic loss, lost earnings and lost earning capacity, and let's distinguish between the two of them. Lost earnings are just that, time missed that should be compensated, past and future. If the plaintiff was out of work for 6 weeks as a result of the injury caused by the defendant, they should be compensated for the 6 weeks of earnings. If they're going to be out for another 10 months in the future after the trial, they should be compensated for the time that they will be out. These are earnings that they are earning now or would earn in the future, and they are quantifiable fairly easily. The second category is less easily quantifiable. This is lost earning capacity. This is a reduction of the value of the services in the workplace, a narrowing of the range of economic opportunities due to the injury. So let's take an example. If one is a plumber and they are out of work for 3 weeks, we would pay them what they had earned for 3 weeks. And that's what they would get paid. But let's say one is now only an apprentice plumber. They have not graduated to a master plumber, and now they are injured, and as a result of that will never be a master plumber and won't earn what a master plumber earns. As a result, they have had a narrowing in the range of their economic opportunities. They should be compensated for this narrowing in the range of economic opportunities. Just the same, all of you are law students in law school. If you were to face a traumatic injury that would not permit you to engage in the practice of law, you would face a loss of earning capacity. That is, you would no longer be able to earn what lawyers earn, and we would have to predict this into the future. You would have a narrowing, as I've said, in a range of economic opportunities due to the injury. Now, obviously, you're saying this requires predicting the future, and it does, and generally this will require expert testimony who will come in. We will bring in what is known as an economist who study these things, who will use actuarial tables, who will use job tables, and will be able, with a good degree of certainty, that is reasonable certainty, discuss and predict what was that narrowing in the range of economic opportunities. This is lost earning capacity, very distinguishable from lost earnings. Let's talk about some other non-economic damage issues. How do we prove them? Remember, these are the soft, what I'll call soft injuries: pain and suffering, emotional distress, loss of companionship, loss of the enjoyment of life. How do we prove them? As I said, pain and suffering, emotional distress. How do you prove them? Because we can't stop the pain and the suffering. We can't give back one's loss of enjoyment. We can't remove the emotional distress. We can only award monetary damages. How do we do it? That is, how do we quantify? How do we place a money value on these? And that is very difficult. And it then translates, how do you argue this to the jury? Well, there are a number of arguments that are discussed in your book, and I'll just talk about these very briefly here. There's the per diem argument. So saying to the jury, what should we pay for 1 hour of pain? What should the plaintiff be awarded for being in, for example, 1 hour of excruciating pain? And then you would say, okay, but this plaintiff is in pain 10 hours a day. So if it's $1 an hour times 10, then we would pay this plaintiff $10 a day. Now, if this occurs every single day, and we would say the plaintiff was in pain for 1 year, then we would say 1 hour times 10 hours a day times 365 days a year. You get the idea. That's how it works. Another argument that's used is the job offer. What should we pay this defendant whose job it is to suffer, to walk around with only one leg and to have to use the prosthesis? What should we pay him for that? Finally, there's what's known as the golden rule. And this is that, ladies and gentlemen of the jury, what would you require to walk around with a prosthesis? What would you require to suffer that kind of pain? What amount would you need? Now, per diem arguments are permitted in most jurisdictions. However, some they aren't. And when they are permitted, the plaintiff must raise this argument in the opening part of their closing argument. They cannot wait till rebuttal to raise it. Some jurisdictions permit job offer, and most do not permit the golden rule argument. But you need to look at the law of the jurisdiction where you practice to determine which of these arguments are permissible and which aren't. Let's talk finally about losses to others. That is loss of consortium. There again are two kinds of loss of consortium. There's economic, which is support and services. So what support and what services need to be replaced due to others' injury? The best example of this is husband and wife. The husband is the one who stays home and takes care of the children. The wife goes to work. If the husband is catastrophically injured so that he can no longer take care of the children, well, then the wife has to hire someone to come in and take care of those children. That is an economic loss that she has suffered as a result of her husband's injury. There are also non-economic losses of society, companionship, affection, sexual relations, comfort, and solace. So now again, the husband is catastrophically injured. The wife and husband can no longer engage in sexual relations. This is a loss to her. Also, he can no longer engage in the activities that the couple used to do. This is a loss to her. She should be compensated for this loss. And both of these are considered loss of consortium. Now, let's take a look at who is eligible to seek this loss of consortium. First of all, before I talk about who is eligible, loss of consortium is a derivative claim. That is, the husband who has the primarily injured party must prove his injury, that is the negligence of the defendant, and be awarded damages. If he can prove his injury, then the wife's claim of loss of consortium will be permitted. In most jurisdictions, loss of consortium is permitted for the spouse. That is the husband and the wife, or the husband and husband, wife and wife. If the jurisdiction permits any type of marital relationship, they will most likely permit loss of consortium for the spouse. Most jurisdictions also permit loss of consortium to children. That is, when children have lost the companionship or the advice of a parent, they can claim loss of consortium. Likewise, parents have been permitted to claim loss of consortium when there has been a catastrophic or fatal injury to a child. That is, they have lost the loss of enjoyment, the companionship of their children. And in some jurisdictions, this is even extended to grandparents who have lost their grandchildren. So you can see it can run close and as well far afield. This concludes this video session on personal injury damages. Again, you are reminded to go to the Twin site and to fill out the video assessment for this video lecture.